Good morning, everyone, and welcome. Our first case for argument this morning is Paula Walrick versus Samsung Electronics. Is it Dvorotsky? Close?
Good morning, Your Honors. May it please the Court. Shai Dvorotsky for Respondents Appellants Samsung Electronics America and Samsung Electronics Company. The Court should reverse the District Court's order compelling arbitration based on straightforward application of black-letter principles of procedure, evidence, and contract law. Starting with procedure and evidence, a party seeking to compel arbitration must present evidence, not just allegations, that the parties agreed to arbitrate. That's because under the Federal Arbitration Act, Section 4, and Supreme Court precedent, the question of contract formation is always for the court, and for a jury if there's a genuine issue of material fact. This Court's case law therefore requires the proponent of arbitration to produce evidence of an arbitration agreement. The issue here is that appellees have produced zero evidence that any of them has an arbitration agreement with Samsung. And that issue breaks into two problems: attestation and particularity. First, allegations, which are all that appellees have, are simply not evidence as a matter of black-letter law. Each appellee would need to attest, for example, in a declaration made under penalty of perjury, to facts showing an arbitration agreement with Samsung. If anyone can't do that, the court is without power to compel arbitration. Second, as to particularity, bare-bones factual attestations are no more sufficient than bare-bones allegations. Each appellee would need to identify him or herself and provide contact information, identify which device he or she purchased and when and where, and the carrier, and if possible, provide the serial or IMEI number for the device. That information is necessary for Samsung, and in turn for the district court, to evaluate whether an arbitration agreement exists. Samsung doesn't have a direct-to-consumer relationship with phone purchasers, so it doesn't have records that allow it to determine, based on the bare-bones allegations in appellee's petition, whether each appellee in fact has an arbitration agreement with Samsung. The district court thought that it, quote, must accept the unverified and unattested, quote, word of over 30,000 individuals. But a motion to compel is like a motion for summary judgment, not a motion to dismiss. That follows from this court's precedent in cases like Tinder and Cass. The court therefore erred in accepting appellee's allegations as true, rather than determining whether appellees proffered sufficient evidence to support those allegations. The district court relied on a discrete list of named claimants attached to the petition. But that list isn't evidence because, again, no appellee swore under penalty of perjury that they have a Samsung device and a valid arbitration agreement. In any event, that list only has personal identifying information like name and residence, which is not evidence that one agreed to arbitrate with Samsung. The district court also relied on the AAA's determination that appellees had met the administrative filing requirements. But the AAA doesn't require claimants to establish at filing that they are bound by an arbitration agreement. It instead requires claimants to simply attach an arbitration agreement to their demand without proof that they're actually bound by it. It's as if I went on Google and searched Samsung Galaxy arbitration agreement and attached it to an arbitration demand. All the AAA did was to process the claims. It never determined that each appellee has a valid arbitration agreement with Samsung. And so lacking evidence that each appellee actually had an arbitration agreement with Samsung, the district court was without power to compel arbitration, and the district court's judgment should be reversed for that reason. The district court's judgment should also be reversed based on basic arbitration principles and rules of contract law. Appellees and Samsung agree that the arbitration agreements, assuming the parties agreed, commit fee questions to the AAA under the AAA rules. The exemplar arbitration agreement that the appellees have put forward is at SA 1162. The dispute here, therefore, comes down to whether the AAA applied its rules and determined that Samsung violated the rules by declining to pay fees, and that its decision not to pay fees was a refusal to arbitrate. The simple answer to that question is no. That follows from both the rules that the AAA has in place for mass arbitrations that were incorporated into the arbitration agreement, and from the AAA's communication with the parties in this case. Mass Arbitration Rule 10D provides that a party may decline to pay fees, at which point the opposing party can decide whether to advance the fees. If the opposing party decides to advance the fees, the parties have to arbitrate. But if neither side wants to pay the fees, the consequence under Rule 10D and under Rule 1D is that the parties will not arbitrate and can instead go to court. That's exactly what happened here, and that's how we know that when the AAA here applied Rules 10D and 1D and closed the arbitrations, sending the appellees back to court if they wished, it was simply doing what the parties' alleged agreement required. Appellees claim that by declining to pay, Samsung was refusing to arbitrate, but again, the rules say just the opposite by providing the option to decline to pay fees. The AAA's communication to the parties, this is at 5 SA 1275 to 1276, confirms that the AAA was not finding that Samsung had violated the rules, but rather was simply applying the AAA rules. That letter notes that Samsung declines to pay the fees. Claimants also decline to pay the fees so that the matters may proceed, and as a result, under Rule 1D, the AAA, at the claimant's request, is closing the arbitration so that either party may choose to submit its dispute to the appropriate court for resolution. The Ninth Circuit in LifeScan, the Fifth Circuit in Dealer Computer Services face similar circumstances where the AAA, applying its rules where one party did not pay, closed the arbitrations, sent the parties off to court, and both the Fifth and the Ninth Circuits held that in that situation, the court couldn't second-guess the AAA's determination. If the court has no questions, I'll reserve additional time for rebuttal.
Well, I have questions that potentially bear on appellate jurisdiction.
Sure.
What has the district court ordered concretely? I ask that because I looked for the district court's order and didn't find it. And it may be because the district court didn't enter one.
So the district court didn't...
District court wrote an opinion, but so far as I know, did not enter any order separate from the opinion.
It did not enter a separate order from the opinion.
So what has the district court actually ordered? Or is it just written an opinion?
So I believe that the district court has granted the motion to compel arbitration, and at page RSA 30, when it turns to the fee issues, it says finally the court turns to whether to compel Samsung to pay fees. And then it goes on to discuss...
And Samsung means which of the defendants?
I think it's referring collectively to both defendants.
Yeah, well, that's another problem, isn't it?
I'm sorry?
It's very hard to know whether we have appellate jurisdiction until we know what the district court has ordered, against whom, and what remains for decision in the district court.
So, Judge Easterbrook, I think the key issue here is that nothing remains for decision in the district court because...
The district court said it was staying proceedings. You can stay proceedings only if there's something left for decision. Did the district judge give a clue what he thought was left for decision? Obviously, I'll be asking these questions of the plaintiff's counsel as well, but it's the first problem that we have to encounter to get anywhere.
So I agree with you that there was no basis for the district court to enter a stay, and that's precisely why the minute order stay that the district court did put in place is not one that defeats appellate jurisdiction. That's what the 5th, 9th, and 11th circuits have held in similar situations where there is a ruling on an order to compel arbitration in a standalone action. I think that the relief here that was ordered against both Samsung entities, Samsung Electronics America and Samsung Electronics Company, which again the district court is referring to collectively as Samsung. And in the section of the district court's opinion on fees, that is where I think the district court is saying, I'm just looking for the exact language here. So in the conclusion, the court grants petitioner's motion to compel arbitration by ordering the parties to arbitrate, specifically ordering Samsung to pay its fees so they can. That, I think, is the particular order that the district court entered that makes this a final determination of the motion to compel.
Do you think there's any relation between this case and Smith against Spizzirri?
I don't think there is. Smith versus Spaziri is a case in which there were underlying claims brought in the district court, and then the district court compelled arbitration. And then the question is whether to enter a Section 3 stay in that situation. There is no Section 3 stay that can be entered here. Section 3 by its terms doesn't apply because this is not a case that was brought on an issue referable to arbitration. The only relief sought in this case was a petition to compel arbitration. So I don't think that Smith bears on this case, but I think that the reason there is appellate jurisdiction, again, as the 5th, 9th, and 11th circuits have held in similar situations, and this court's description of the law in American International is consistent with this, where the only relief that has been ordered, or the only relief that has been sought, is on a motion to compel arbitration, then an order granting that relief resolves the sole issue before the district court and leaves nothing for the district court to do, making its order final. Yes, the district court here purported to enter a minute order stay, but again, as other circuits have explained, when the only relief sought is to compel arbitration, there is simply nothing left to stay, and that purported stay does not defeat appellate jurisdiction.
All right, thank you very much.
Thank you.
Mr. Gupta.
Good morning, Your Honors, and may it please the Court, Deepak Gupta for the appellees. I'd like to start with Judge Easterbrook's question about the orders in the case. We don't think
Is there one?
Yes, I think there's not what we regard as a final order or judgment of the Court, but the
Is
Court
there an order separate from the opinion?
So the opinion was titled Memorandum, Opinion, and Order. And
That's just irregular. The federal rules don't provide for such a thing.
There's no separate document.
No separate document.
And then in the conclusion section, I think Mr. Duretsky is correct that the Court said it was granting the motion to compel arbitration and ordering the parties to arbitrate, and then separately...
Against whom? Both defendants to arbitrate with all plaintiffs?
Yes.
Even though I don't even understand you to claim that every plaintiff has an arbitration agreement with both defendants.
Well, that's right. The arbitration agreement is with...
And since you're not even making that claim, what can this requirement possibly be?
Well, the claims are brought against both Samsung Electronics Corporation and Samsung America, and the arbitration agreement says by its terms that it also encompasses disputes with the parent company. And so under the New York Convention, there's jurisdiction over that.
This question wasn't about jurisdiction. It was about trying to make sense of what the district court thinks it has done in the absence of anything like a separate order.
I think what the district court thinks it has done with its memorandum of order is order the parties to arbitration, and then separately in document
Order
entry
both
50,
parties to arbitrate with all plaintiffs, whether or not they have an arbitration agreement with any particular plaintiff.
Well, I think that the court concluded that there was an arbitration agreement that bound all Samsung customers and that the claimants had shown that they're Samsung customers. I'd like to turn to that, but first, if I may, I'd like to address jurisdiction.
Yes.
When
I have the same Smith against Spaziri question for you.
Sure. Yeah. So the question in that case is about the propriety of a dismissal rather than a stay. The question is whether courts are required to stay proceedings once there's been an order to compel arbitration. Here, there's no dispute that what the district court did was stay the proceedings pending arbitration.
What proceedings are they?
So any proceedings that would occur, and I think...
But what?
So
what did the plaintiffs ask for that has been stayed?
So this is just like in FC staying
No, I'm asking a concrete question.
Yeah.
What did you, your clients, ask for that has been stayed?
Well, we asked to compel arbitration. We asked...
Well, that hasn't been stayed.
That hasn't been stayed. We
So
asked
what has been stayed?
to compel the payment of fees, and as this court has recognized...
So
that can...
you need to tell me what you asked for that you think has been stayed.
Well, I think with respect, Judge Easterbrook, that's not the right question. What this court has said over and over again in cases like Halim versus Great Gatsby's is that the proper course of action when the party is invoked an arbitration clause is to stay the proceedings. And the court has explained...
When there is an underlying request for relief, for example.
But the court has made clear that it's not only when there's an underlying request for relief. So, for example, in the Kawasaki Heavy Industries case, this court said that the court retains jurisdiction over a matter so that it can
if it
effectuate...
retains jurisdiction. But if it's given the plaintiff all the relief they want...
Right.
Your argument seems to be that a district court, by a stroke of the pen, can defeat the Green Tree principle. That if the only thing at stake was arbitration and it's been ordered, then that's appealable.
Well,
And you seem to be saying perhaps the district court thought that he could just sign away the Green Tree right of appeal.
Green Tree is actually the exception. The norm is to stay. And this court has made clear in the Kawasaki case that the stay is not just to address pending claims. It's also to address arbitration-related issues that can arise. If you look at Chapter 1 of the Federal Arbitration Act, it's a set of issues that can arise during the arbitration. For example, parties may need to come back to the court for requiring order to pay fees, the appointment of an arbitrator in order for witnesses. And so this court has said that the norm is a stay, and that's what other courts have said as well. And I think if you want to look at a decision to understand the purpose of a stay pending arbitration, you can look at the Sixth Circuit decision in Preferred Care.
Yeah, I'm not asking about decisions in other circuits.
Right.
I'm trying to figure out concretely what, if anything, is left for the district court to decide in this case.
I think what the district court understood is that this was a hotly contested dispute between the parties where one set of parties was refusing to arbitrate. And the district court understood that, as often happens, the parties may come back to the court because one party hasn't paid the fees or because there's been a dispute about how the arbitration will proceed. And International FC Stone was a very similar case where the appellant came to this court and in argument they were asked the same question that you're asking, Judge Easterbrook. What is the purpose of this stay? And they said there's nothing to stay, there was no reason for the stay, but the district court understood otherwise. It understood that the parties may come back, and indeed they did, because they had to dispute about where the arbitration should take place.
That sounds like saying that no case is ever final because the parties always may come back.
No, but I think
they may file a Rule 60B motion. In an ordinary civil case where there's a judgment on a jury verdict, the parties may file other motions, and therefore nothing is final.
The design of the Federal Arbitration Act is that the final judgment is after the arbitration is had, when there is an award and then there are proceedings.
But if the thing sought in the case is in order to arbitrate, that has to be the final judgment. The district court won't do anything else because the plaintiffs have received the relief they requested.
That is not the design of the Federal Arbitration Act, and no circuit holds that. So
look, I'm just not impressed by statements about something of the design. I'm impressed by people pointing me to statutory language, right?
Well,
but statements about the design of is an implied argument about the intent of people, and I don't care about their
Let's
intent,
stick with the text.
But I care a lot about the text.
Let's stick with the text then.
Good.
So the text of the Federal Arbitration Act, I think, is quite clear. And you've talked about this in your Moglia decision. It affirmatively
who wrote the decision of the court is not relevant.
Okay, so just look at the text. It says that it lists three kinds of orders: orders granting a stay of any action under Section 3 of this title, directing arbitration to proceed under Section 4. And let's focus on that. Section 4, a Section 4 proceeding is what my friends on the other side don't want to call an independent proceeding, but it is, right? It's where there isn't a pending action, there are no claims. Someone comes into court and they say, we want to compel arbitration under Section 4. And so the relief that they get is the order to compel arbitration. And what Congress is saying in B2 is that when you obtain that order to compel arbitration, it is not an appealable order, and that's why it's listed there. And that overturns some of the complex judge-made law that pre-existed Section 16.
Nobody loved the NLOS.
Exactly. And, I know we don't want to talk about decisions, but I do want to flag one decision of yours, Judge Easterbrook, Bradford Scott. from 1997 where you explained exactly this. You said Section 16.
You? Right. Ad
the
hominem
court,
arguments
this
just don't
court.
cut it. The court may have explained
Right.
something.
What this court said in Bradford Scott is that Section 16 replaced that much maligned Enloe Edelson doctrine with a simpler approach under which anti-arbitration decisions are immediately appealable, while orders enforcing arbitration clauses may be appealed only following the close of the entire case. And where do you understand where the close of the entire case is? If you look at Section 9 of the Federal Arbitration Act, it explains how you get a judgment after an arbitration. That is the judgment that Congress had in mind. So the route in Greentree where there's a dismissal, that's actually an aberration, and the Supreme Court is going to decide in Smith whether that aberration persists. But the conventional understanding is that under this statutory design, that there is a stay, and even if there isn't a stay,
Yeah, I'm
even
not
if you-
sure that the justices would be altogether happy with the Seventh Circuit saying, well, there's Greentree, but it's an aberration. So we move right along.
I don't mean to suggest that you need to get into that at all. I think the question presented in Smith is not remotely presented here. That's a merits question. This is a jurisdictional question. And the Supreme Court has said in Arthur Anderson that Section 16 keeps those jurisdictional and merits lines
Well, I
very
need to
separate.
stop bothering you about jurisdiction so you can use your remaining time to argue the merits.
Well, I'm happy to just make a couple of other points about jurisdiction, if I may, Your Honor, because I think, even if you didn't have a stay, and I understand, Judge Easterbrook, you have some concerns about the district court entering the stay. This was precisely the concern that this court had in Napleton, the idea that a district court could be a gatekeeper about whether there was jurisdiction. And the Supreme Court overturned Napleton in Greentree. And so the effect of Greentree is that the district court does have a say in whether or not they keep the case or whether there's an appellate route. And even if there weren't a stay here, even if Section 16 didn't exist, and you were just analyzing this case under traditional principles of finality, you still don't have what the law would have regarded as a final judgment. Even before Section 16, stays were considered inherently interlocutory, they still are, and stays pending arbitration were considered interlocutory and were not final judgments under Section 1291. And so in the remaining time, I may just turn to the merits. And what you heard from Mr. Dvoretsky is that we didn't establish with evidence that there were arbitration agreements on which the district court can compel arbitration. I actually think the dispute here is very narrow. The parties agree that anyone who uses or purchases a Samsung device, of the devices in question, is bound by Samsung's broad arbitration clause. The parties agree that in a motion to compel arbitration proceeding, the standards are somewhat analogous to summary judgment, but it's a summary proceeding. The parties agree that the initial burden is on the proponent of arbitration, and that once that initial burden is satisfied, the burden shifts. So the parties agree on all of that. And my friend on the other side filed a 28J response a few days ago that cites a decision from the Sixth Circuit by Judge Murphy that I think is a very helpful analysis of this murky procedural area that honestly hasn't been theorized very much by the federal courts. Surprising, given that the statute has been around for 100 years. But it's a case called Boykin versus Family Dollar. And that court explained there that the initial duty to present evidence is the duty to present evidence that would allow a trier of fact to find that an arbitration agreement exists. Here, we did submit evidence. The evidence was the record of the prior proceeding on this very issue before the arbitral body that Samsung chose. And that record included the claimant's individualized filings before the AAA, in which each claimant stated that they are a Samsung customer bound by Samsung's broad arbitration agreement and provided exactly the kind of biographical information Mr. Dvoretsky alluded to. That record also showed Samsung's failure to rebut those filings, despite information in its possession showing which claimants were customers and significant vetting that took place before the AAA. Family Dollar also holds that circumstantial evidence in the lead up to a motion to compel is appropriately considered. That's at page 840 through through 41 of that decision.
What
There-
form was the spreadsheet admitted in the arbitration?
In what form?
In what form?
In the
Sworn?
arbitration, the spreadsheets were not, I don't believe that the AAA's rules required a sworn form. And I think Your Honor's question
So it
goes to
wasn't
the...
submitted in a form that would be admissible in federal court as evidence?
Well, the rules
Or
under-
accepted in
the
federal
summary
court as
judgment rules are
evidence.
not that the summary judgment evidence has to be evidence that's admitted at trial. And had there been, I want to make clear, there was no...
All we have is the raw spreadsheet is the bottom line, right? Listing, listing customers who were solicited for the lawsuit via email and social media advertisements.
No, I think we have much more than the spreadsheet, Chief Justice Sykes. What we have is the record of what happened in the arbitral proceeding. This is as if you have a review of an agency proceeding or the question is about whether someone is exhausted, the first thing you would look at would be the record of what happened before the proceeding. And there, whenever individual issues were raised by the AAA or by Samsung, they were immediately cured. And so what Judge Leibenweber relied upon was not just the list of claimants, but the fact that all of this information had been presented. These people identified themselves as Samsung customers bound by the arbitration agreement. And at that point, given all of that evidence, the burden shifted to Samsung to identify some individual issues. They never did. What they wanted
Well,
to do...
there really was no evidentiary showing about the existence of an arbitration agreement for these tens of thousands of plaintiffs.
Well, there were...
All there was a submission of the spreadsheet to the
No,
arbitrators.
I want to be clear, there was
At
not
filing, and the filing requirements don't require
not
anything
just
more
the
than that.
spreadsheet. There was also an individual demand by each and every claimant attesting to who they were, that they were Samsung customers, where they lived, their email address, their phone number, which would identify them to Samsung as customers in their accounts.
And what form was that submitted in?
That-
Affidavit?
Those were in the demand forms in the AAA.
Not an affidavit,
And
not a
so-
sworn statement.
Right, and
so
so
it's
that's-
not evidence in
So
federal court.
let me get to the heart of what I think is animating your question, which is it sufficient that there were not sworn statements? And I do want to make very clear that Samsung never made an evidentiary objection to the admissibility of any of this evidence in the district court. Had they done so, the district court would have ruled on that, and we would have been able to supplement with whatever evidence was necessary to make that showing. But they didn't make that
You've got
objection.
affidavits from all these tens of thousands of plaintiffs?
Do we
Sworn,
have-
sworn statements that they are
Well,
parties
if
to
the
an arbitration agreement?
If they had made an evidentiary objection, we certainly would have put forward those statements. Yes, and to answer your question,
But Samsung asked in the district court for those statements, and the plaintiffs declined to file them. You say we certainly would have put them forth. It doesn't seem consistent with what actually happened.
well, there was no objection to the form of the evidence. There was no admissibility evidence. Actually, if you look in the district court, Samsung didn't raise this issue until the last 2 pages of
Was
its
there, to
motion to
speak in
dismiss.
terms of the rules of evidence, was there an offer of proof?
I think we made an offer of proof in the sense that we put forward
In the sense, did you make an offer of proof as the rules of evidence use that phrase?
Yes, we provided the record before the AAA of what had occurred. There were 20 exhibits to the petition to compel arbitration showing what occurred there, and I think I can represent to the court that the Claimants Council have already begun gathering signed declarations under penalty of perjury out of an abundance of caution, and would be prepared to file those to the AAA before the process arbitrator at the appropriate time.
I don't see how filing anything before the AAA counts when under AT&T, it's the judge who has to decide whether there's an arbitration agreement.
That's absolutely right. That's absolutely right, Judge Easterbrook. The judge decides whether there is an arbitration agreement. All I'm saying is that it doesn't make a lot of sense to view this question from the perspective of as if it were a case where the parties started out in court. It's relevant what happened before the AAA. It's relevant that all of these arguments were fleshed out before the AAA, and at every opportunity, Samsung never identified individual issues or claimants, and when they did, those issues were cured. And I think the reason is because what Samsung really wants to be able to do is not have those issues be cured, because the reality is they know who is a Samsung customer. They know whether north of 90% or more of these people are people that are in their records and that are bound by the arbitration agreement. And so what they want to be able to do is raise questions about one or two people and hold those issues open so that it seems as if there is some doubt about whether all of these people are bound by the arbitration agreement. But every time that Samsung actually raised these issues, they were cured. Thank you.
All right, thank you. Mr. Zaretsky, you had some time left.
If I could, I'd like to address jurisdiction and the evidentiary argument. With respect to jurisdiction, Judge Easterbrook, in response to your questions, a few points. One, starting with the statutory text, under 9 U.S.C. section 16A3, a final decision with respect to an arbitration that is subject to this title is appealable. It's only an interlocutory order that is not. And under the Supreme Court's decision in Greentree, a final decision is one that leaves nothing left for the district court to do. That's what we have here. With respect to what the district court did order here, at the beginning of the district court's opinion, it defines the two parties here, Samsung Electronics America and Samsung Electronics Co., as Samsung. And as to them, at RSA 36, it is ordering them to arbitrate and specifically to pay the fee. That is also memorialized at docket entry number 50. That's the minute order. That's the minute entry that also has the purported stay. With respect to the purported stay, the appellees in this case did not ask the district court to stay anything. They didn't request a stay. The only thing they requested was the relief they received, which is the order compelling arbitration and for Samsung to pay the fees. This court's decision in FC Stone dealt with a different situation. That was a case where a FINRA arbitration was brought. The court ordered arbitration to a different arbitral body, and there remained a pending question before the court about whether to permanently enjoin the FINRA arbitration. That there is what was stayed and what made the decision non-final. Judge Easterbrook, with respect to your questions about the separate judgment, a separate judgment is not required in order for there to be appellate jurisdiction. We addressed this in our jurisdictional memo.
Yes, that's Bankers Trust against malice. I understand that. But it sure does help.
And perhaps it would be advisable for district courts to do that. But
we have urged all of our district courts to enter proper final decisions. 6 out of 7 of our districts do so. Your case happens to be in the 7th.
Even so, under Federal Rule of Appellate Procedure 4A7B, which I know you're familiar with, the separate judgment is not required in order for there to be a final appealable judgment, where we, as we have done here, waive that requirement. With respect to the evidentiary issue, first of all, lawyers' statements that are not sworn are simply not evidence. The spreadsheet that Mr. Gupta refers to that was submitted before the AAA, it's at SA 1214 to 46. It is not sworn. It is simply a spreadsheet with limited information about the claimants. It does not include what model phone they owned, any information about the phone, where or when they bought the phone, and the claimants here are asserting claims as owners of Samsung devices, and so they need to provide the court information establishing that they had arbitration agreements with Samsung as owners. It is not our burden to rebut non-evidence by the appellees. Under the Boykin case that Mr. Gupta referred to from our 28J letter, it makes that clear that the burden shifts to the opposing party to rebut evidence only when the moving party has actually put evidence before the court. And here, there has simply been no evidence put before the court, or before the AAA for that matter, establishing an arbitration agreement. As for the argument that Samsung surely knows all of its customers, it doesn't. Again, as I said in the opening argument, Samsung is not primarily a direct-to-consumer company. This is not like Verizon or Facebook, which has records of all of its customers. Samsung does not. It sells mostly through carriers or through retail stores, and so Samsung is simply not going to have a complete customer list. That is precisely why we need evidence from the appellees, and the court needs evidence from the appellees in order for Samsung to carry any burden that it might have. But lastly, I would say on the fee issue, the court should simply reverse outright on the basis that even assuming there are arbitration agreements with each of these customers, the AAA applied its rules. That's what the purported arbitration agreements call for, and as the Fifth and Ninth Circuits held in Dealer Computer Services and LifeScan, the court has no basis to second-guess that decision by the AAA. If the court has no further questions, we ask that the judgment be reversed.
Thank you.
Thank you.
Our thanks to all counsel. The case is taken under advisement. Our second case for argument this morning is Tribune Media Company versus the Commissioner of Internal Revenue. We've still got some moving parts here.
There's a lot of paper in this case, so.
Indeed. All right, Ms. Bringer,
Yes, good morning.
good morning.
May it please the court, my name is Nora Bringer, and I represent the Commissioner of Internal Revenue in this appeal. In 2009, Tribune received $714 million for its disguised sale of the Chicago Cubs baseball team and other assets. This case concerns only the tax issues in 2009, and in that year, Tribune paid tax on $33 million of its gain. Tribune claimed that Tribune was at economic risk for $673 million in loans that funded the payment to Tribune for Tribune's sale of the Cubs assets. Other than the claimed tax benefits, it made no sense for Tribune to give up 95% of the Cubs assets and put itself on the hook for the vast majority of the payment it received in return. The parties' arrangements made it look like Tribune had economic risk for the debt, the senior debt in particular, but the substance of the arrangement was otherwise. Under the parties' arrangements for the Cubs transaction, as petitioner's expert testified, Tribune's risk in the senior guarantee was as low as 0 and a maximum of 0.43% of the senior debt. The tax court erroneously found that to be irrelevant.
I thought your own expert, or one of your own experts, testified that the guarantee was worth between $6 and $19 million.
Your Honor, we're talking about the senior guarantee, and our position is that the guarantee of the senior debt is what's relevant to the Commissioner's appeal. And those numbers came from the Commissioner's expert's analysis of both guarantees. But that expert explained that if the subordinated debt was found to be equity, which is the case here, that the senior guarantee was effectively worthless. And our expert pegged that at $30,000 in the low end to about $1 million in the high end. So both experts are in agreement here that if we're just looking at the senior debt and the senior guarantee, then the risk is as low as 0 and at most de minimis. In upholding the tax treatment of the senior debt, the tax court failed to apply the plain text of 2 anti-abuse regulations. And at a minimum, this case should be remanded for the tax court to undergo the correct analysis. I'd like to start with the anti-abuse rule in section 1.752-2J. The tax court incorrectly limited its analysis under the anti-abuse rule in subparagraph J to the hypothetical facts generated under the constructive liquidation test in subparagraph B. But that constructive liquidation test determines a partner's economic risk for recourse partnership debt except as otherwise provided in the regulation. And the anti-abuse rule in J is one of those other provisions that's an exception to the constructive liquidation test. The tax court erroneously found that the facts of the constructive liquidation test instead governed the anti-abuse rule in J. And that was incorrect. The anti-abuse rule applies to the actual facts and circumstances and considers the substance of the arrangement. But the tax court ignored the actual facts, circumstances, and substance in subsuming the anti-abuse rule to the facts generated by the constructive liquidation test. The tax court found it relevant that there was an extreme unlikelihood that Tribune would ever have to pay out on the senior guarantee. Everyone expected Chicago Baseball Holdings to pay its debt, and especially the senior debt, but the tax court assumed that CBH could not pay its debt. The fair market value of CBH's assets at the time of the transaction was $844 million, which is nearly 2 times the amount of the senior debt. Yet the tax court assumed that the Cubs would be deemed worthless. For all of these reasons, the tax court fundamentally misapplied the anti-abuse rule in J. The tax court also mistakenly thought that it had to assign the senior debt to a partner and decided that that partner was not RAC and instead assigned the debt to Tribune. But that's incorrect. Under this rule, an obligation may be disregarded or treated as the obligation of another person. There was no need to assign this to one of the 2 partners here. The tax court, in ignoring the actual facts and circumstances here, failed to analyze the substance of the arrangement. And under federal tax law, when you look at the substance of the arrangement, it means that you look to the real world facts, and as the Supreme Court said in the Frank Lyon case, objective economic realities. Here, the tax court did not consider any of the facts or objective economic realities. In Feldman, this court explained that for there to be substance, economic substance, in the federal tax context, the transaction must make a meaningful change to the party's economic position. Here, there is no meaningful change to Tribune's economic position from the senior guarantee.
Why does the constructive liquidation language in the tax regulations then tell the court to assume that the value of the underlying asset is gone to 0? Why shouldn't it say, try to figure out what the actuarial value is? I ask this question should be clear. It looks like the form over substance argument is the commissioner's effort to make the constructive liquidation test go away, even though the constructive liquidation test is the commissioner's own test. And that troubles me.
Sure. So the constructive liquidation test is easy to apply. It's straightforward. It's administratively simple. And in fact, governs the assignment of recourse debt in the vast majority of cases. I think that's why we're here in only the 2nd case concerning this anti-abuse rule. But Treasury promulgated that constructive liquidation test at the same time that it promulgated the anti-abuse rule, because the extreme circumstances under the constructive liquidation test can be manipulated through careful planning to make it look like there's risk when there really isn't an economic substance. So the anti-abuse rule, although rarely invoked, is a backup to those circumstances where the constructive liquidation test ends up with a partner being assigned risk for debt that isn't really there in the real world. So these 2 rules work together. And that's, quite commonly the pattern in federal tax cases. Since 1935, the Supreme Court has upheld again and again, and many other courts have upheld, the idea that the Commissioner, the Internal Revenue Service, can look behind the technical requirements and look to whether there's actual economic substance in a transaction. And here, the tax court simply never looked to the real facts. And that's what the anti-abuse rule requires in J. And the parties' arrangements here did make it look, under the constructive liquidation test, like Tribune had risk. But in fact, the substance of the arrangements was quite different. Tribune's collection guarantee put up 3 extremely unlikely hurdles for Tribune to cross before Tribune would ever be on the hook for the senior debt. The first hurdle was a default by CBH on its debts. There were numerous protections in place to prevent that. The cash waterfall agreement is one such protection, where revenues that were projected to be between 7 and 10 times the annual debt service in the senior debt flowed first to the senior debt. There was an operating support agreement arrangements, 2 different documents, a letter agreement and then a loan agreement. Now, under the letter agreement, the Ricketts parties, and that's a defined term in the agreement, agreed that at any time the commissioner could direct them to cause the transfer of funds to the baseball club in the form of an equity contribution or an unsecured subordinated loan. Those funds were intended to go to the operating expenses of the Cubs. Now, while a loan was limited under those two agreements, there's no limit to the equity contributions that the commissioner could require, leaving an unlimited pot of money available for operating expenses, which would free up money to pay the debt. The second hurdle is foreclosure, and we lay out in our briefs the many, many barriers to actual foreclosure on the Chicago Cubs baseball team. Major League Baseball testified that it had tools to avoid seizure of a team as collateral under all circumstances. Those tools included the Major League Constitution, the debt service rule, and other ways that Major League Baseball would step in before it would allow a team to be foreclosed on. In addition, if foreclosure ever was allowed to occur, the senior debt was strongly over-collateralized. As I mentioned earlier, at the time of the Cubs transaction, the fair market value of CBH was nearly 2 times the amount of the senior debt. And the possibility that there could be a foreclosure and that there would not be sufficient assets to satisfy the senior debt was nearly impossible, as is reflected in the testimony of the experts from both parties. I'd like to move on to the general anti-abuse rule, unless there are further questions about the subparagraph change. So the commissioner also argued that the senior debt guarantee should be disregarded under the subchapter K anti-abuse rule in 1.701-2. Now, to take advantage of the rules under subchapter K of the Internal Revenue Code for partnerships, there are several requirements in this regulation. One of them is that the partnership must be bona fide, and each partnership transaction or series of related transactions must be entered into for a substantial business purpose. The tax court again did not apply the plain text of this regulation. The tax court incorrectly held that the business purpose requirement does not apply to every agreement, but rather to the function of the partnership as a whole, which would eviscerate this rule.
But the
if that were
tax
the
court
case.
then went on to say, and in addition, I find that each of the question clauses has a business purpose.
Yes, Your
And
Honor.
you are not saying that any of those findings is clearly erroneous. So what's the point of attacking the first statement when it was backed up by the second, and the second is not challenged?
Your Honor, the tax court did eventually get to what it thought was an analysis of the risk on this under the senior guarantee. That was, in fact, clearly erroneous. We point out some of the issues
I
with that.
searched your brief for the phrase clearly erroneous. It does not appear in the brief.
We
Not
may not
once.
we may not have used that phrase, Your Honor, but we did explain in our brief that the tax court erroneously relied on evidence that was
Yeah,
not relevant.
that's part of the problem, at least for me. Your brief is written in large measure as if we were going to make the original decision. That is, what is an error? And that's true of legal arguments, but of factual arguments and characterizations, like whether clause X in an agreement serves a business purpose, our review is deferential. So I don't see how you get anywhere just by saying, well, you should do it differently. You have to show it's clearly erroneous. And as I say, that phrase does not appear even once in your brief.
Well, even so, Your Honor, I think we did show that there was clear error in the tax court's brief
By the way, that
discussion.
phrase appears exactly once, clear error, in the statement of review, but not
Yes, Your
as
Honor.
applied to any of the tax court's findings.
Well, I do think that we showed that the tax court's alternative analysis, once it finally got there, was clearly erroneous. First, the tax court erroneously looked to the risk on both guarantees. As we discussed earlier, the risk on the senior guarantee, both experts testified, was minuscule. And it was inappropriate and incorrect for the tax court to support and bolster Tribune's risk on the senior guarantee with its risk on the subordinated guarantee when the tax court found that the subordinated debt was not debt at all. The tax court also should not have looked to 2016 documents from Standard & Poor's, which were prepared by an analyst who did not understand the transaction, who did not know the details of the transaction, and did the same thing the tax court did, which was lump together both tranches of debt here. The focus should have been on the senior guarantee, and Tribune's risk on that was as low as zero and at best de minimis. It should be disregarded for federal tax purposes. I see that I'm well into my rebuttal time. So
Thank you.
just for that, thank you.
Ms. Zaharsky.
Good morning. I'm Nicole Saharsky, representing the Taxpayers Tribune and the partnership. So the tax court correctly determined that this was a debt finance distribution, and it held a 10-day trial. It heard from 30 witnesses and 11 experts, and it made findings on all of these questions about the business purposes and the economic risk of loss. And so to turn to the...
Did the tax court make a finding about the value of the guarantee as applied to the senior debt as opposed to the subordinated debt?
Yes, the tax court made findings on both. It determined that both mattered because even if you don't treat the sub-debt as debt for tax purposes, it was still a real obligation in the world that Tribune would have to pay if the circumstances came to pass. So it said we should consider both of those the same way that S&P and others considered both. And the numbers that it gave based on the expert's testimony was for the senior debt, a valuation of approximately $1 to $2 million. For both together, I think the numbers went between $13 million and up to $24 million. And the the tax court made a number of findings very specifically after this trial that the guarantees had economic value. That's on page 113. Had a real world effect on Tribune's credit rating. That's on 111. That there was a genuine concern that CBH may not have the cash flow, that it could decrease significantly so that the guarantees would be called. That's on page 100. Actually, the experts agreed that there was a risk of default that they put within 4 years between 4 and 5%, and that's a real risk of default. In terms of GAAP accounting, the tax court looked at that and said that there was, even though it was remote for GAAP purposes, there was still economic value. And then, of course, it looked at the economic value of the senior and sub-debt. That's on page 112. And so we think that analysis was entirely appropriate, supported by the record, the trial, and not clearly erroneous, all of those factual findings. Now, if we look at the regulatory questions, the specific regulatory requirements, and the legal arguments that the commissioner is making here, the bottom line is that Tribune's guarantees were real guarantees that could have been called. Everyone agrees that they were real guarantees. The commissioner says maybe they wouldn't have been called, but if they had been called, Tribune would have to pay. It had to have the money to be able to pay, and it always had that money available. It was like a life insurance policy. You hope you don't have to pay out on it, but if you need it, it has significant value. And that is essentially what Tribune was offering here as part of this package deal. And when it offered to parties to engage in the Cubs transaction, it proposed this package. And the package was, we will transfer the Cubs assets to the partnership, and we will also provide this guarantee. And the guarantee was supposed to be a sweetener that, since Tribune had the money, it could provide this backup if something went wrong with the loans.
In your view, what happens when the debt is repaid? Is that equivalent, and the guarantee then falls out, is that equivalent to forgiveness of a loan?
Well, from the taxpayer's perspective, so from Tribune's perspective, the tax is paid over time. And so while the guarantee is still in place, there is a certain amount of the gain on the Cubs assets that are recognized as income every year, and tax is paid on that.
Is that a result of the conversion back to C status, or is it a different source?
Well, as a general matter, the effect of something being a debt finance distribution as opposed to a deferred sale is deferral of the tax as opposed to paying it all in 1 year, which is 2009. As Your Honor points out, there was a short period of time right after this transaction where Tribune was an S corporation, and then because of the bankruptcy, it reverted to a C corporation. From the period of time when it was an S corporation before it became a C corporation again, the gain was treated as, some amount of it was treated as income, but the owner of the S corporation didn't pay taxes on its income because it was an ESOP, an employee stock ownership plan. And so for that period of time, although the gains were allocated as income, tax wasn't paid on them. But then after Tribune became a C corporation again, Every year, the amount of the gain was recognized, allocated, these remedial allocations as income, and Tribune paid tax on it. And eventually, actually, there became a point in 2018 where the guarantees were forgiven, essentially, or no longer, Tribune no longer had to give the guarantees. It paid tax at that point. And then there came a point in 2018-29 where Tribune sold its 5% remaining interest in this partnership, and then it paid tax at that point. So Tribune is paying tax on this. It's not as though this is some tax avoidance mechanism. This is something that Congress...
Well, tax deferral is to an extent tax avoidance.
It's
Depends
something
on the rate of, basically the social rate of interest. But yeah, I
Right,
just
but
wanted to understand exactly how you saw when the gains would be recognized.
Certainly, and this is something
And I
that...
think I understand it.
Yeah, I'm sure you do. This is something that Congress recognized in terms of wanting to permit this type of tax deferral for debt finance distributions. So there was this case that came out in the early 1980s, the Raffan case, that did not treat a guarantee as a liability that could be used for purposes of a debt finance distribution. Congress, in the Massive Tax Reform Act in 1984, put into the public law Treasury Department promulgate regulations that account for guarantees to be used as part of a debt finance distribution, and do it without regard to this decision in the Raffan case. So we know that Congress specifically contemplated that guarantees could be used in this way for debt finance distributions, and then if you turn to the Treasury Department regulation, that's exactly what it does. And so just to turn to the regulations here, because I think there's the tax court completely understood how these regulations work. I mean, the bottom line is, because these are real guarantees, there is not abuse under the specific anti-abuse rule or under the general anti-abuse rule. So if I start with the first one, the specific anti-abuse rule, that's the one that's in the regulation 1.752.2. That regulation starts with the constructive liquidation test. It says, let's assume that everything goes badly and the partnership has no assets, all of the liabilities come due, its cash is worthless. Is there any partner that has to pay? And here, because of the guarantee, which is a recourse liability to Tribune, Tribune would have to pay. Everyone agrees, worst case scenario, Tribune would have to pay. And so then there's this other provision in J, which is the anti-abuse rule. And it asks, essentially, despite the legal agreement, the guarantee, is there some reason that the parties have agreed to eliminate their risk of loss or to create the appearance of a risk of loss where in fact none exists? And I'm just looking at the exact language of this provision. It's that the facts and circumstances have to indicate that there's a principal purpose of an arrangement between the parties to either eliminate the partner's economic risk of loss or create the appearance of the partner bearing the economic risk of loss where in fact it doesn't exist. Well, what is that about? It is about a situation in which there really is no risk. There is no risk because the partners had some kind of side agreement. And we know that because there's an example that's in the regulation just a few lines down, and it gives an example of what would be abuse under these circumstances. And in that situation, one of the partners, A, has taken on that it will pay for the partnership's losses, but it doesn't have any money to do it because it's a subsidiary and its parent company made sure that it would not have any capital to pay that. So in those circumstances, they said, well, we're not going to allocate that liability. That's an abusive arrangement because there's no money to pay. There's also the Canal Corp Corporation decision that the tax court addressed, which was a similar situation. You have a subsidiary that has no money to pay if the liability came due, and then also there was an arrangement where the subsidiary would be paid back, and so there was just no economic risk of loss there. And there's a reason, I think, in this regulation that the question is risk or no risk. It's not magnitude of the risk, likelihood of the risk, and that's because of the need for certainty. I mean, these rules are about allocating losses or liabilities to partners. Partners need to know this for all different kinds of purposes, even figuring out their income every year. It's not just about debt finance distributions. And the reason that we have the constructive liquidation test is that it provides certainty, as the government says. And here, the rule that the government's suggesting under the anti-abuse rules, it's like some amount of risk isn't good enough. We don't know how much. They never tell us what the rule is. It's just some amount of risk isn't good enough. And that's not what this regulation says. It's not what the example says. And frankly, it would create a lot of problem because there are a lot of guarantees that companies enter into, and now they wouldn't know, if the risk is good enough or not. So this is really, in our view, just a made-up test by the government that would destroy the certainty that exists now. I'd like to talk separately about the general anti-abuse rule that the commissioner is relying on. So this is a provision that says that each partnership transaction or series of related transactions must be entered into for a substantial business purpose. This is the regulation 1.701-2. And the tax court in this circumstance first interpreted the regulation because there was a disagreement between the parties in terms of how should you interpret the regulation, and then made factual findings. The interpretive question was, do you look at the overall transaction, the Cubs transaction, for a substantial business purpose, or do you look just at the guarantee? And the tax court said, looking at the text, looking at the examples that Treasury provided, you look at the overall transaction. The overall transaction here was the formation of the partnership, the taking out of the loans, the giving of the guarantees. All of that had a substantial business purpose, which was to transfer this ownership of the Cubs and form this new organization. And so that's our view too, is that that's the right way to look at this regulation. But the tax court said, even if you look at it the other way and ask, does the guarantee itself have to have a substantial business purpose? I find that it does, because it ensured that those loans were going to be paid, and it had economic value for all of those reasons that I talked about earlier with respect to its effect on what it would be worth according to the experts, its effect on Tribune's credit rating, there being a real risk that in fact there would be a default and the guarantee would be called. And those are all factual findings by the tax court that are not clearly erroneous. And so there's just no basis here, we think, under either of these anti-abuse rules to invalidate this transaction. I mean, really, both of these rules at their heart are asking, like, is this a real transaction? Did it have any economic effects out in the world? And the answer is absolutely yes. These debts and this guarantee were accounted for in Tribune's financial statements. They were accounted for by S&P. The experts all agree that they exist. And the tax court made significant, substantial findings on all of these things that the government just doesn't refute. And we think if the government's view of the regulations were accepted, it would essentially throw these regulations into disarray, because there would come a point at which a guarantee is just not good enough anymore. I'd like to just turn briefly, if I can, to the debt versus equity issue, which is the issue on which we cross-appealed. So the reason that we cross-appealed here is that the tax court's holding, it just doesn't reflect the reality of over 10 years of operating in this arrangement, that everyone understood this to be debt. And there is just a mountain of objective evidence here in terms of how the parties understood the subordinated debt. And just to be clear, we are not asking you to find facts or revisit the tax court's facts. For the most part, the historical facts here are undisputed.
For the most part, except that the tax court has got this 13-factor, I refuse to call it a test. It's got this 13-factor list. And it says, well, I got a little of this, and that's positive, and I got a little of that, and it's negative. Right. It sounds like it's reached a characterization that can only be called a decision of fact. I mean, how does one avoid that? Consistent with your argument that the tax court's other findings of fact should be accepted.
Right, I absolutely understand the question. First of all, I think the analysis is what this court, that is appropriate, is what this court has done in prior cases, which is you don't have to look at all 13 factors, you just look at the ones that make sense in this case.
You just look at 11. Or maybe you can find 2 more.
You look at
how is it anything other than a finding of fact how these things weigh up?
Right, this ultimate question, whether it's factual or legal, this court has said both. There are precedents from this court that say both. And this court has acknowledged that it has said both. We think that it ultimately is legal, but we're not asking you to revisit that determination here. What we're asking you to do is to correct the tax court's legal errors, because we think the tax court had some pretty serious legal misunderstandings that influenced the way that it made this final determination, and those are things that are reviewed de novo. I think everyone agrees that legal errors are reviewed de novo. So just to address what those are. First of all, the tax court treated the fact that the subordinated debt was subordinated as dispositive of it being equity as opposed to debt. And that just wasn't right. It can be a relevant fact that the debt is subordinated if the effect of subordination is that it is paid on par with equity. But if it's still paid on par with, for example, the general unsecured debt, which is what happened in this case, then it's debt. So the mere fact of subordination just doesn't make something equity as opposed to debt. The question is, like, how is it subordinated? How will it be paid? And the circumstances in this case made clear that it was paid before equity, on par with that other debt. The second legal error was the treatment of related parties. The tax court here essentially assumed that related parties can't create real debt. That's just not reality at all. Related parties create real debt all the time, like look at parents and subsidiaries. And certainly here what the tax court should have done is look at the terms of the agreements, which made clear that there was a certain repayment of principal and interest, the terms, the consistent practice of repayments, etc. And then the third thing, which we think is the most significant, is the third-party evidence here. This, unlike most cases, you have a lot of interested third parties who cared about whether this subordinated debt was debt or equity. It mattered to Major League Baseball and to the 3/4 of the teams that had to approve this transaction because they were worried about how much debt Tribune potential or the partnership potentially was going to take on. You also had ratings by S&P. You had the senior debt holders specifically limiting the amount of this sub-debt, which they wouldn't have done if it was equity. And you had the bankruptcy court understanding that it was debt. So, in those circumstances where the tax court made those errors, we really think that you should at least remand, if not find in our favor. I see that I'm at the end of my time. I'm happy to answer questions if there are any.
Thank you.
Thank you.
Ms. Bringer.
Thank you, Your Honor. I'd like to touch on a few things, turning back to the senior debt and the Commissioner's appeal regarding the senior guarantee. The fact is that the tax court never looked at the real-world facts with respect to the senior guarantee, which is required under both of these anti-abuse rules. The tax court, in its analysis of the subparagraph J rule, looked just to the hypothetical facts generated by the constructive liquidation test. And when it turned to the subchapter K anti-abuse rule, at best, when it finally got to the senior guarantee, as we discussed earlier, it looked at evidence regarding both guarantees and never considered the zero to de minimis risk that Tribune actually had on that guarantee. And the senior guarantee is all that matters when you're looking at whether Tribune's treatment of the senior debt was correct. There was no reason for the senior guarantee in the real world other than tax benefits. Yes, it was built into the transaction from the beginning, but there's no evidence that it had any impact on the terms or the amount of debt that the lenders put forth to CBH. And in fact, the evidence in the record is the opposite of that. Tribune concluded that its guarantees had no effect on the amount and the terms of the debt, and that there was no benefit to the bidder, to the Ricketts' and to CBH from the senior guarantee. And so there's no business purpose for that guarantee. It made no difference to this deal other than making it appear as though Tribune had economic risk for the debt, when in fact the truth is that it did not. Are there any other questions the panel has for me?
Did you want to address the cross appeal briefly? There were three legal errors that were raised after the debate about whether the tax court's decision was based on factual findings or contained legal errors. So if you could just focus in on the three legal errors. The treatment in general of the subordinated debt as equity sort of as a categorical matter. That's one of the legal errors that's been claimed.
Sure, Your Honor. So the standard of review for that is clear error, and it's a facts and circumstances test that looks at the whole picture. With respect to one of the issues that was raised, the related party issue, it's certainly possible for related parties to enter into genuine debt. The petitioners cite two cases that involved a parent corp and a subordinated or a subcorp for those debts. Here, the situation is quite different. The related parties are controlled by close members of the same family, and it's appropriate for the tax court to look at those relationships and consider whether one entity, which was funded and controlled by Marlene Ricketts, for example, ever would have enforced any enforcement rights that it had at the very end of the line against the entity owned by the family trust. So certainly related parties can create genuine debt. Here, their parties are so close and their interests are so aligned that the tax court correctly found that the subordinated debt was equity and not debt. Are there other particular issues that you'd like me to address, Your Honor?
That was one of the major legal errors that was claimed in your position, as I understand it, is that it wasn't a legal error, it was just a factual finding, a difference of opinion about a factual finding.
Yes, Your Honor, that's correct. It's certainly perfectly permissible for the tax court to keep in mind the close family relationships that controlled all of the entities that were involved in the debt here.
Understood. Thank you.
Thank you.
Our thanks to all counsel. The case is taken under advisement. Our next case for argument this morning is Jane Doe versus the Mukwonago Area School District. All right, Mr. Azir, did I pronounce that correctly?
Azure, Your Honor.
Azir, all right. You may
It's all
proceed.
right, no one gets it. Good morning, members of the court. I represent the defendant appellants in this case, the Mukwonago Area School District and Joe Cook. This case illustrates the type of ambush tactics that are disfavored by the courts, and unfortunately, the district court exacerbated the issue. On June 30th, 2023, the day before a 4-day holiday weekend, the plaintiff filed the complaint, the motion for a TRO, and the motion for preliminary injunction. Rather than serving the school district, plaintiff's counsel emailed a copy of those documents to me at 4:54 p.m. on that Friday while I was in Nevada attending my grandson's birthday. Despite the fact that this occurred before a holiday weekend, I flew back early. We spent the entire holiday weekend working on responding to the TRO, and on the 4th of July filed a response. Amazingly, on July 11th, 2023, before conducting a hearing and before the district was even served with the complaint, the district court granted the preliminary injunction. This court in Wheeler versus Talbot said that a preliminary injunction may not be issued until notice is provided to the opposing party and a hearing conducted, and that did not happen in this case. Instead, the district court, without having any evidence before it, made the determination that this case was not factually distinguishable from Whitaker, found that the plaintiff had demonstrated a likelihood of success on the merit, and that irreparable harm would occur if the preliminary injunction was not granted. All of this was done, once again, before the district was even served. What the district court, in essence, said was that the facts don't matter. As long as a plaintiff alleges that a transgender student was not permitted to use a bathroom,
What your adversary says is you could have submitted facts to the district court even though your client was not yet a party. That's the real argument, and I wish you'd address it.
Absolutely, Your Honor. Rule 65A1 bars a court from issuing a preliminary injunction until after a hearing is conducted. And this court's...
No, you're not dealing with my question. Your client had not been served with process and was therefore not technically a party.
Correct, Your Honor.
But couldn't it have submitted evidence anyway?
It could have submitted evidence, yes, Your Honor, but it was not required to. And the reason
Right. So you shouldn't, I think, you should stand on that rather than saying, well, my client didn't have an opportunity to submit evidence. It did. It had actual knowledge of the litigation, but it hadn't been properly served.
which this court has ruled is insufficient. In McMasters versus United States, this court stated that actual notice to a party is insufficient. The court does not have jurisdiction over a party until Rule 4 is followed and the individual is expressly served. In fact, this court dealt with almost an identical situation in Mid-Continent Wood Products versus Harris. That's found at 936 Fed 2nd 297. In that particular case, this court addressed a situation where the plaintiff's counsel had provided email copies of all the pleadings to the opposing party. They had not been served, however. The court nevertheless took action, and this court said action cannot take place unless there is actual service performed, and it was not done in this particular case. This court also in Wheeler versus Talbot specifically said, Rule 65 contemplates that the issuance of a preliminary injunction shall be upon notice to the adverse party and after a hearing. This court went on to say that a hearing embodies the right to be heard on the controverted facts as well as upon the law. And that was not done in this case. Instead, what the district court did was issue an ex parte preliminary injunction. And this court, as well as other districts that we have cited, have specifically prohibited that from being done.
Well, it wasn't an ex parte preliminary injunction. You had notice.
We had actual notice, Your Honor. We were not served.
Oh, I understood. Your service argument came in your reply brief, so it's arguably waived. It wasn't raised in your opening brief. So that complaint may be outside of the scope of the appeal, but to the extent that you're complaining about a lack of notice, you had notice. You were notified of the filing of the complaint. You had a copy of it. You were notified of the motion for a TRO and preliminary injunction, and in fact responded to it, and the district judge waited until receiving your response to rule on the motion. Rule 65 doesn't require service.
Rule 65 requires a hearing before an issuance of a preliminary injunction, Your Honor. And again, in Wheeler versus Talbot, this court repeated that.
It requires an opportunity for a hearing. But that gets back to the question whether the school district's actual notice wasn't sufficient for it to request a hearing and tender evidence.
And again, Your Honor, I would point back to, if we look at the differences in timelines between what happened in the Martinsville case and what happened in this case.
I'm not asking for a difference in timeline. I'm asking a question about the rules, right? Was there anything that disabled the school district from asking for a hearing and tendering evidence?
From physically asking for a hearing, no, Your Honor. There wasn't. But again, we anticipated that the district court would not only follow the express statements in Rule 65A1, but would also follow the jurisdictional requirement that this court has set forth in the multiple cases that we provided. In this case, while we had actual notice, we did not have the opportunity to have a hearing. And when the court...
That's what I don't understand. Why was there no opportunity to have a hearing?
Because the court was required to conduct a hearing before...
No, you're not addressing the question. Why was there no opportunity to have a hearing when your client had actual knowledge of the suit, and you've already agreed with me, could have requested a hearing, but chose not to? What you can do is stand on your right and say, we don't have to ask until we've been served. You can make that argument. But it's completely bogus to say there was no opportunity for a hearing.
Well, I agree with you, Your Honor. I agree. We are standing on our position, and that is what we argued in our brief. We are not required...
So then you should say, there was an opportunity for a hearing, but we don't have to avail ourselves of it until served with process. You can make that argument. It's a different argument from saying we never had an opportunity for a hearing.
Understood, Your Honor. In this particular case, the court did make this decision without conducting a hearing, without having any evidence before it, without having any facts before it. And a court is required to balance all of the facts when making a determination as to whether it's going to issue a preliminary injunction. When the court in this case determined that this matter was factually indistinguishable from Whitaker, it did not have anything before it to make that determination. There were no facts in the record. There was no testimony that was provided to indicate that there was any type of irreparable harm. There was no indication of the balancing interests. There was no indication as to objections or privacy interests from other individuals, and that is simply because a hearing was not conducted. I see that I'm in my rebuttal time, so I'll stop here.
That's fine, thank you. Mr. Schlachtus?
Thank you, Your Honor. Glenn Schlachtus for appellee. May it please the court. No,
Well, Mr. Schlachtus,
Yes.
what is your best authority for the proposition that a court may enter a preliminary injunction before the defendant has been served in process? I understand TRO before service, right? The normal sequence is TRO, service, and then you proceed toward a preliminary injunction. I was looking for cases where a preliminary injunction was entered before the defendant was served. I didn't see any. Maybe you found some.
Your Honor, since that precise issue was not raised by the school district, we haven't addressed that in the brief. I can point to cases from this court that say no evidentiary hearing was required in this circumstance, but can I specifically point to cases addressing that service question? No, because it hasn't been raised, not because they're not there. I honestly don't know, because the question has not been raised. What we've focused on is the question that defense counsel, the issue defense counsel has raised about the propriety of the lack of an evidentiary hearing here, and I think the court has spoken quite clearly to that in several cases, including Promatech from 2002, where the court said, finally, it was not necessary for the district court to hold a hearing before ruling on the motion for a preliminary injunction. An evidentiary hearing is required if the non-moving party raises genuine issues of material fact in response to a motion for a preliminary injunction. However, the party seeking the evidentiary hearing must demonstrate that it has and intends to introduce evidence that, if believed, will so weaken the moving party's case as to affect the judge's decision on whether to issue the injunction. And so that burden was on the school district, and the school district did not do anything to satisfy that burden. Now, I think coming back to your question, Judge Easterbrook, about service, Rule 65 does contemplate entry of a preliminary injunction on, quote, notice to the adverse party, end quote. It does not say notice and service.
Service is required to make someone a party. Until the school district was served, it was not a party. I mean, that's just technical rule speak. You become a party by being served.
At the same time, though, the court has said that that very provision in Rule 65 does not require service. And I would point
No, Rule 65 isn't what requires service. It's required elsewhere in the rules.
Well, the court has affirmed entry. The court has said that service is, that notice is left to the discretion. What constitutes proper notice is left to the discretion of the district court judge in affirming entry of a preliminary injunction in People ex rel. Hartigan.
There is no doubt that the school district had notice, but it wasn't a party because it hadn't been served with process, right? The question is, what happens under that circumstance? You make somebody a party by serving them with process. That's just technical. That's how it happens.
And
Rule 65 talks about notice to parties. The school district wasn't a party. You get the problem?
I do understand, Your Honor, and I will note that they were served several days after.
They were served
entry.
several days later.
Several days later, exactly. And I
They're
think
a party now.
they are. And I think this also gets at the question of why the district court never, or the fact that the district court never, before they were technically a party or after, never said, I'm sorry, the school district, I may have said the district court, the school district, both before and after they were technically a party, never said to the district court, hey, we have evidence that we want to present. We want to have an evidentiary hearing. And they had plenty of opportunity to do so both before and after they were technically a party. They could have done that in their initial response to our motion for a TRO and a preliminary injunction. They could have done that once the district court issued the TRO, obviously foreshadowing its analysis of the preliminary injunction and saying it would soon issue a ruling on the preliminary injunction. It would have been quite reasonable at that point with the TRO having been entered to say to the district court, we want more time. And then after the preliminary injunction was issued, they certainly could have said to the district court, Your Honor, we expected to have a hearing. We didn't have one. We have evidence. We want to put it in. They didn't do any of that. Instead, the first time they raised the issue, supposedly having evidence that would have been pertinent to our motion for a preliminary injunction, was in this court.
Was there any hint in the TRO order that the judge was planning to schedule a hearing on the preliminary injunction motion?
There was not.
And
There was
what happened between July 6th when the TRO was entered and I guess it was July 11th when the judge converted the TRO to a preliminary injunction?
Procedurally, nothing happened, Your Honor.
So the judge didn't invite further briefing, evidentiary submissions?
No,
And
the judge.
Did the TRO order say that the judge was planning to proceed summarily?
The judge said in the TRO order that he would, quote, soon be speaking further to the preliminary injunction. There was no indication that further briefing was requested or that a hearing would be held. There was nothing that could reasonably have suggested to the school district that an evidentiary hearing was on the horizon.
Well, was there something suggesting to the school district that there was not an evidentiary hearing on the horizon?
There was nothing suggesting.
Since the rule contemplates one?
Well, the rule contemplates one in, as the rule has been interpreted by this court, the rule contemplates one if there are relevant factual disputes that need resolution. And
Well, that's not what the rule says, right?
On its face, but it may not, but as interpreted by this court several times, including in Prometech and other cases cited in our brief, this court has been clear that the evidentiary hearing is not required unless there are relevant factual disputes to resolve, and with good reason, because there's no point to an evidentiary hearing if you don't have factual disputes in front of the court. And then as Prometech says, it is
But the usual way you find out whether there's a factual dispute is to wait until the defendant becomes a party and then listen to what the defendant has to say. You don't enter the judgment before the defendant is a party.
Well, the court did
It really
listen.
is fundamental about litigation that you have to wait for service before you order the remedy.
The court, of course, did listen to what the defendant had to say. They submitted a brief. They even quoted from what would have been evidence in front of the court, except that they didn't attach those particular documents. And so they did have the full and fair opportunity. They were listened to. The court simply did not agree that they had created factual disputes requiring resolution. And Your Honor, if I could just briefly turn to one other argument that has been prominent in defense counsel's brief, although not raised today, which is this whole issue about the process, not the Rule 65 process, but the process in the school district that they believe plaintiffs should have submitted to under the new policy that the school district created in late June, or under a special education referral process. That process was completely unnecessary and in fact would have served as an obstacle to the exercise of plaintiffs' rights here. What Whitaker and Martinsville tell us is that so long as a transgender student's need for access to the restroom consistent with their gender identity is genuine, they are entitled to that access. Here, before there was even a whiff of any dispute, the school district knew that plaintiff's need was genuine. They knew because throughout plaintiff's nearly 3 years as a student in the school district, she had presented as a girl and she had used the girls' restroom, all without incident. And then when the dispute arose, the school district also had medical documentation on top of that. So given that state of play, for defendant to require plaintiff to submit to a process under that new policy or as a special education referral was really to erect an obstacle to her exercise of her rights. It was not to create a pathway to her ability to enjoy those rights. And I'll add, it was not a small obstacle. It's clear from the record that this process was going to be rather involved, time-consuming, and involve a host of school officials. And as the district court correctly found, there was no possibility that that process was going to result in the school district affording plaintiff access to the girls' restroom. That process only contemplated the possibility of giving her additional support in coping with the denial of that access. And the district court correctly understood that that simply makes no sense. That if you are harming somebody by discriminating against them, the way to alleviate that harm is not to put your arm around their shoulder, it is to stop discriminating. So any which way you look at it, this whole process is, I see my time is up. Thank you, Your Honor, and we respectfully request that the court affirm entry of the preliminary injunction below. Thank you.
All right, you had a little bit of time left.
Your Honor, I want to clarify that we did in fact raise this issue of service in our initial brief. It's on page 13, it goes on to page 14. It says, in fact, defendant appellants had not been formally served with a copy of the summons and complaint when the district court issued its preliminary injunction on July 11th. We cited Wheeler. A court may not issue a preliminary injunction without advance notice to the adverse party, and defendant had not been served when the district court acted on plaintiff's motion. So we did raise that issue in our initial brief.
Well, it was mentioned, it wasn't really
mentioned.
developed.
It was not an issue.
We also
It's
identified...
not enough to preserve an argument just to mention a fact and then hope that the court will develop an argument based on that fact. What's the first time you made an argument about this?
Understood, Your Honor. We would argue that we did raise it in our initial brief. We also raised to the district court the various discrepancies in the factual record, and we brought to their attention that we were challenging all of those positions. The district court in its TRO said that it would take up the preliminary injunction separately. It never said it would rule on it without conducting a hearing. It never even indicated it. It said it would take it up separately. It didn't. As to the last facts that were raised by my opposing counsel at the end, talking about the process and the procedure that was used here, unfortunately, the district court had no evidence of that process before it. So it could not make any ruling on that because it chose not to conduct a hearing and actually gather that information and evidence. Thank you, Your Honors.
Thank you. Our thanks to all counsel. The case is taken under advisement. And our final case for argument this morning is In re Edwards, or I'm sorry, In re Edward Johnson.
The Chapter 13 trustee gets appointed or how she operates her office except for oversight. Chapter 13 trustee operates an office that collects funds from debtors, collects fees, and pays creditors. The case at issue is about whether or not the Chapter 13 trustee can keep those fees in unconfirmed cases and how she gets paid. Section 586 of the Judicial Code sets the standing trustee's statutory amount of fees that she can take. Those fees are taken upon receipts of funds from the debtors. The problem with that bankruptcy court had is that 1326 also talks about what happens to those two fees when a case is dismissed and not confirmed. In this case, the debtor proposed a plan, actually two different plans, for over 9 months. Over those 9 months, the debtor was unable to confirm a plan. The case was eventually dismissed. Once it was dismissed, the debtor moved to have the trustee's fees disgorged. The trustee properly took her fees when she received the funds from the debtor.
How is that consistent with the language of Section 586E2? It says the trustee will collect such percentage fee from all payments received by an individual under plans in cases, etc.
Correct.
So how were these fees received under plans? I understand how the fees...
It either gets approved by the court or it doesn't get approved by the court, but it's still a plan. When the courts try to make some of the...
I don't understand how it's a plan rather than a proposal by a litigant.
It is a formal plan. It's a form that gets filled out by the debtors. And if it becomes a confirmed plan, that's different, but it's still a plan. You can't have, it's not just a loose proposal that the debtor's going to somehow make payments. It's structured to secure debt. It's structured to
It's rather like
administer.
saying a motion and a judicial order are the same thing.
A trustee can't do anything with the payments received by way of distribution to creditors until the plan is confirmed, correct?
That's not true. There's adequate protection payments that are proposed in the plan.
I'm sorry, there's what kind of?
Adequate protection payments. Part of the plans call for the trustee to make payments pre-confirmation to certain debts such as secured debts. What that covers is that when say for instance a vehicle, as the vehicle depreciates, we pay payments to that car creditor to cover the depreciation of that asset. So the trustee does make pre-confirmation payments.
Pursuant to the plan
Pursuant
or
to the
pursuant to
plan.
statute?
To the plan. The plan
I
proposes
just
the
don't
amount.
see how it's pursuant to a plan. It's required by the note, and it's required by law unless the security interest is going to be enforced.
Correct.
But how is it pursuant to a plan when there hasn't been a plan approved by the court?
Because the plan provides for those adequate protection payments.
You're just taking a motion and a plan as the same thing. Now, maybe that's bankruptcy jargon, but is there any reason to believe that that's the meaning of that word in the statute?
Well, the statute uses the plan. It says the proposed plan. It calls it the plan.
It doesn't say proposed plan. It says...
Shall propose a plan.
No. The statute says, and I've quoted it before, all payments received by such individual under plans in the cases, etc. It doesn't say proposed plan. It doesn't say under anything else.
The bankruptcy code says that the debtor shall propose a plan. Section 1326 says the payments...
Counsel, just listen to what you're saying. It says the bankruptcy code says the debtor shall propose a plan. The proposal is not itself the plan. What's the difficulty here?
I find the difficulty the other way around. I don't see, if you have a proposed plan, it is a plan. It can become the confirmed plan later, but there's still a plan that is proposed. That's the plan that everyone has to look at in order to determine whether or not the debtor is complying with the bankruptcy code. He has to propose something. It's not just a loose proposal. It actually is a plan. It has terms. It has payment amounts. It has secured debt listed, how they're proposed to be paid in the plan. All those things are put out there so that it can be analyzed and find out what to do with if the plan is confirmable. But it's still a plan. If it's a confirmable plan, it'll get confirmed. If it's not a confirmable plan, it may not get confirmed. But there's still always been a plan there. Consequently, as Section 1326 says, unless otherwise ordered by the court, the debtor shall commence making payments 30 days after filing the plan. So there is a plan on file. If there was nothing on file, we wouldn't even know what the plan payments were proposed to be. And again, those are payments that the trustee has to make adequate protection payments from. Those are payments that the plan alludes to and how much those amounts are. The creditors can object to those payments if they think they're too low. They can object to their treatment in the plan if they think it's improper. The trustee is also bound, under her duties, to object to plans that are not proposed correctly. If, say, the Chapter 7 liquidation test is wrong, that would be in a plan, we would have to object to it. But there's always a plan there. It's just whether or not that plan gets confirmed or not. In terms of the fee that the trustee takes on those adequate protection payments, I think she receives them under the 586 East provision. 1326 also provides specifically under Section B, before or at the time of each payment to creditors, under the plan, because there is a plan that has been proposed, that there should be paid adequate protection payments and the trustee fee. It would make no sense to only have that paid with no plan. If you're going to pay adequate protection, the plan can't be confirmed. So there is a plan that has been proposed. Again, it's kind of a circular argument to say there's no plan there, but you pay adequate protection, you take a fee on adequate protection, but there's no plan. So I think it makes it very ambiguous. It makes it convoluted to find out that, no, that's not how that's going to work. So again, I think the code's very clear. We get the fee either on receipts or through 1326B. And I think the trustee should prevail both instances.
Has any circuit adopted that line of argument? Certainly the 9th and 10th have rejected it. Has it been adopted anywhere?
It has not yet, but I'm hoping you will. The problem, I think, though, with the 9th and the 10th, neither one of them looked at 1326B. They never looked at how that statutory part comes into play. They went with a lot of the statutory reading on the very generalized, does 586 combined with 1326, how those kind of fit together and what should happen. But they never really went on to say, well,
Do you know whether it's pending in any other circuit?
the Second Circuit is it's under consideration. I think it's
Been argued in the Second Circuit. Is it pending in any other circuit?
I said the second. I'm sorry.
That's what I said. It's been argued in the Second Circuit. Is it pending in any other circuit?
Not that I know.
Okay,
I'm
thank
sorry.
you.
I misheard you. The rest of the time I will save for my rebuttal.
That's fine.
Thank you.
Mr. Miller.
Good morning, Michael Miller on behalf of the appellee. Your Honors, I wanted to jump in to what Judge Sykes was talking about in relation to the appellant, and that is he's really stressing on these adequate protection payments being part of the plan. And like you had stated, is that under the plan or is that under the code? You're right, it's under the code.
Where is that found?
It is under section pre-confirmation payments are required under the code pursuant to 361, 362D1, and 1325A1CA. So those pre-confirmation payments do not come
361, 362D, and
325A1C.
what kind of payments are all these generically for non-bankruptcy experts?
Sorry, they're pre-confirmation payments for adequate protection payments, which usually come under secured creditors like car payments and things like that. So they have to be made prior to the plan being confirmed.
Is that something different than the carve-out in A2 of 1326? I'm referring to the language, if a plan is
Yes.
not confirmed, the trustee shall return any such payments not previously paid and not yet due owing to creditors pursuant to subparagraph 3.
Yes, that would be different.
That is different.
Yes.
That carve-out is different.
Yeah, the carve out there is the only thing that is not returned is 503B claims, which would be administrative claims such as attorney fees. And there's no carve-out under that section
Well,
for.
no, that's the final clause of sub
Yes.
2. I'm talking about that middle clause of the second sentence of sub 2. If a plan is not confirmed, the trustee shall return any such payments. And here's where I got tripped up. Not previously paid and not yet due and owing to creditors pursuant to paragraph 3. That's like plopped down in the middle of a sentence in a non-grammatical way. What does subparagraph 3 cover
Subparagraph 3,
for non-bankruptcy experts? It says, subject to section 363, the court may, upon notice and hearing, modify, increase, or reduce the payments required under this subsection pending confirmation of a plan. That doesn't make a lot of sense, because that just gives the bankruptcy judge the authority to modify the plan's proposed payments subject to confirmation, right?
yes.
Otherwise, there's a presumption that the amount of the payments to the trustee are those proposed in the plan, or
Well,
proposed
well,
plan, depending.
Right. Well, paragraph 1326, A1A talks about the proposed payments. And then
Right.
1326A2 says those same proposed payments are retained by the trustee until confirmation or denial of confirmation.
Except when they're not,
Right.
because they're paid out to creditors under this, I guess the nomenclature is adequate protection
Yes.
payments to creditors when one of these statutes that you gave me is implicated.
Right.
So retained is not categorical.
Yeah, with the adequate protection payments, usually the way it works is the trustee is dispersing them prior to confirmation. So they're not a part of the plan, and they don't need to be returned because they're already dispersed prior to confirmation.
Come again?
The pre-confirmation payments that are made for the secured creditors for adequate protection, I believe the trustee disperses those prior to confirmation to the secured creditors. So
Well,
they
right, that's why we're talking about them. Because
Yes.
this is the universe of pre-confirmation payments to creditors.
Yes.
That's what I'm trying to get a handle on here.
Yes.
And you're telling me, as your opposing counsel said, that corresponds to these adequate protection payments to secured creditors, which are covered by these statutes that you gave me, and how are those treated for purposes of the trustee's fee? Can the trustee take a fee from those payments?
No, not under our reading because the plan is not confirmed yet. The plan is, until the plan is confirmed and under the plan, the trustee cannot take any fee.
How does that correspond to sub B of 1326?
Under 1326B2,
Sub B says, before or at the time of each payment to creditors under the plan, there shall be paid a fee to the trustee.
right, that is actually the section that triggers when the trustee can get paid because that section,
That's what we're talking about
Right.
here. That's
Sorry.
what the whole fight is about.
yeah, it's under the plan at that point and that's when they can get paid. And it cross-references 586 at that point.
But this doesn't refer to the pre-confirmation payments.
No,
Because,
because the pre-confirmation payments aren't under the plan. And 1326B2 is under the plan only. So the only reference to pre-confirmation would be 1326A1A, which is when the payments are proposed. And then it's referenced again in 1326A2 that those proposed payments should be retained. So those payments include the trustee's fee, so they have to be retained until confirmation, which is under the plan.
except if they're paid for adequate protection to secure creditors.
Though, well, the trustee's fee wouldn't be included in those because those are not under the plan. So our argument is that the trustee's fee doesn't come off those pre-confirmation payments and they don't receive anything on it until confirmation.
Okay.
So because those payments have already been sent out, they couldn't take a fee from
It's
it.
statutory, it's not pursuant to the plan, is your
Yes.
argument? Okay.
Correct. I'm sorry for the
Understood.
confusion. The other thing I want to talk about too is, and Judge Easterbrook had hit on this, 586E2 says under the plan. And there's a lot of other arguments besides the fact that under the plan means confirmed plan. One of the biggest arguments we bring is looking at sections 1226 and 1194. Chapter 12 has a provision under 1226 that says if the case is not confirmed, there's explicit language in there that says the trustee can deduct their fee. Section 1194, which is a section under subchapter 5 for chapter 11, which is small businesses, also has that same explicit language that says if the case is not confirmed, the trustee can keep its fee. So if 586 really says what the trustee thinks it says, that, hey, we can just keep our fee as soon as we get it, that makes 1226 and 1194 surplusage. You don't need those sections. And I think that's why Congress put those explicit language in those sections of 1226 and 1194, but chose to leave that explicit language out of 1326A. And I believe that's compelling here. The other thing is, I believe somebody at the trustee had said that the Ninth Circuit Evans case and the 10th Circuit Dow case, they didn't really look at 1326B. That's not correct. In terms of the Ninth Circuit, the recent McAllister case, they actually explicitly looked at 1326B, and they did an in-depth analysis basically saying that when you do a breakdown of 586 and 1326, 586 is just from the judicial code. It's not the bankruptcy code. It gives appointment of trustees in 13s, 12s, and subchapter 5s. It gives them their percentage, and then it appoints them. However, it doesn't tell us when they can get paid. That's why you look to the bankruptcy code. The bankruptcy code would be for chapter 12s, 1226, subchapter 5s, 1194, and then, of course, our case, 1326. And when we look at 1326, 1326 A1A says the debtor makes payments proposed by the plan within 30 days. Then 1326 A2 says those proposed payments are retained by the trustee until confirmation. And if the plan is not confirmed, the trustee will return all payments except 503B payments. The trustee doesn't argue there are 503B administrative claims, so the trustee would not be getting their fee. Congress could have easily added in the trustee fee as an exception as well, like the 503B, but they didn't. But lastly, and this is what the Ninth Circuit said, is 1326B2 is the linchpin of confirmation. It says under the plan, which is our argument confirmed, the trustee can then get paid, and then it cross-references 586. And that's how we know 586 is clarified by the statute of 1326 that they should receive their fees. If the court doesn't have any other questions, I can conclude. And for those following reasons, I would ask you to affirm. Thank you.
Thank you. Mr. Olivadotti, and you had a little bit of time left.
Again, I just want to reiterate that 1326 talks about the plan. It talks about payments under the proposed plan, the plan. The Ninth Circuit, Evans case only works when they insert the word confirmed plan into this reading. That's what counsel was trying to argue. Nowhere in the code does it say the confirmed plan is a trigger pin of when the trustee gets paid. Again, with the adequate protection payments, we have to make those beforehand. They have to come from somewhere. They have to be proposed by a plan. We pay pursuant to that plan, which triggers the payments to creditors under 1326B, and we take a fee. It's specifically provided for that when we pay creditors. So under either reading, I believe the trustee should be able to keep her fee. Thank you.
Thank you. Our thanks to all counsel. The case is taken under advisement.
I just wanted to add one quick comment.
Well, that's rather unorthodox.
Oh, I'm sorry.
Thank you. All right, that concludes our calendar for today, and the court will be in recess.